Hello, everyone. Welcome to the U.S. Immigration Hub. Breaking news: a sweeping shift is unfolding in Washington tonight as Congress passes one of the most far reaching immigration reform laws in modern American history. A law that experts say will redefine the rights, responsibilities, and risks facing millions of immigrants across all 50 states. What lawmakers approved is not a small update or a procedural change. It is a structural transformation of how the United States classifies non-citizens, how it interprets public safety violations, and how it determines who gets to stay, who becomes inadmissible, and who may now face removal even without a formal conviction. The legislation has shaken immigrant communities, energized supporters of stricter enforcement, and sparked new questions about how federal agencies will implement these powerful authorities in the months ahead. You are watching USA Immigration Hub. Make sure to subscribe, like, and share so you never miss critical updates that shape the immigration policies affecting families, workers, students, and residents across America. Congressional leaders achieved what many analysts considered nearly impossible: a bipartisan immigration reform package at a time of deep political division. Lawmakers describe the agreement as a balance between modernization and public safety, but critics argue that the consequences could be severe for lawful residents who believe they were secure under long-standing protections. At the center of the legislation is a dramatic restructuring of how the federal government categorizes non-citizens. Temporary visa holders, long-term permanent residents, and even green card holders are now grouped under a unified enforcement category. This shift removes the legal distinctions that previously shielded certain groups from immigration consequences for minor infractions. For countless green card holders who for years viewed permanent residency as the final step before citizenship, this reform fundamentally reshapes expectations. Previously, lawful permanent residents generally faced immigration risk only when serious criminal convictions occurred. But now, under the new rules, that assumption no longer holds. The bill creates expanded deportation standards tied directly to public safety offenses. And, the example drawing the most attention and concern is the inclusion of driving under the influence. Under the new federal standard, a single DUI incident, even one treated as a misdemeanor under state law, can become grounds for deportation. Legal analysts emphasize that this is not merely an extension of previous policy. It actually represents a significant tightening of federal enforcement authority rooted in the Trump administration's long-standing emphasis on accountability and public safety. The legislation goes further than many expected. Removal proceedings can now be initiated even without a formal conviction. Analysts explained that under certain circumstances, simply admitting to conduct consistent with the definition of a DUI could place an individual at risk of immigration action. Supporters of the measure argue that this standard aligns immigration law with the seriousness of alcohol-related driving behavior, pointing to federal data showing thousands of lives lost annually due to impaired driving. They insist that lawful residents must uphold a higher standard of conduct to maintain their status in the United States. Immigration advocacy organizations, however, warned that these expanded powers may lead to inconsistent enforcement across states and regions. They caution that individuals could face life-altering immigration consequences for incidents that states classify as minor or first-time offenses. Two major changes define this reform's impact. First, the grounds of inadmissibility have been expanded under the new framework. Anyone with a DUI conviction, or anyone who admits to conduct that meets the standard of a DUI, will now be deemed inadmissible to the United States. This includes travelers seeking re-entry, visa applicants abroad, and individuals inside the country filing for renewal, adjustment, or citizenship. Immigration attorneys emphasize that no jail time is required for inadmissibility under the new rules. The standard itself is reclassified as a serious legal and moral violation. The second major change is the tightening of deportation standards. Federal immigration law will now override state definitions, meaning that even if a state categorizes a DUI as a low-level misdemeanor, it can still qualify as a deportable offense under federal authority. This applies across all visa categories from employment-based programs to family-sponsored immigration. The implications are far-reaching. Green cards are now described by federal officials as conditional privileges that can be revoked when public safety standards are violated, which is a significant departure from previous interpretations. The reform also reshapes the definition of good moral character, which is one of the key requirements for naturalization. A single DUI conviction now automatically disqualifies an applicant from obtaining United States citizenship. Attorneys highlight a scenario that honestly many families may find familiar. A permanent resident who has lived in the United States for years, paid taxes, supported a family, and contributed to the workforce may have experienced a single DUI incident years ago. Under the former system, that event might not have affected their long-term immigration plans. Under the new system, that same offense could result in ineligibility for citizenship or even risk of deportation depending on the circumstances. Lawyers are now urging clients with any history of DUI, no matter how old or minor, to seek legal advice before filing renewal applications or naturalization petitions. The legislation allows for retroactive review, meaning older cases can be reassessed under the updated standards. Federal agencies, including the Department of Homeland Security and U.S. Citizenship and Immigration Services, are, preparing to issue detailed operational guidance to ensure consistent enforcement nationwide. Until then, uncertainty remains high. Families across the country are seeking clarity, reviewing their records, and preparing for possible consequences. Immigration service providers report a surge in calls, consultations, and community briefings as individuals attempt to understand how the new law will apply to their specific situation. Supporters of the bill say the reform will restore confidence in the immigration system by enforcing uniform standards and prioritizing public safety. They maintain that law-abiding residents have nothing to fear from the new regulations. Critics, however, argue that the system risks becoming overly punitive and may unintentionally penalize individuals for isolated incidents that states have already addressed. They warned that stacking federal immigration penalties on top of state-level consequences creates uneven outcomes that may disproportionately affect certain communities. The Trump administration has described the measure as a pivotal achievement in its national immigration agenda. Officials highlight the dual goals of strengthening public safety while improving administrative efficiency. The reform package includes modernization measures intended to, streamline USCIS operations. These updates include expanded digital case systems, increased resources for high-demand visa categories, and improved online filing tools. These changes are expected to help reduce the lengthy processing times that applicants and employers have struggled with for years. However, despite these administrative improvements, many advocacy groups believe the strict enforcement provisions kind of overshadow the benefits. They are urging federal agencies to apply discretion and distinguish between dangerous criminal behavior and isolated mistakes. They also call for careful consideration of humanitarian factors that may influence an individual's circumstances. Meanwhile, consulates abroad and the National Visa Center are preparing to implement stricter screening procedures, which analysts expect may temporarily slow visa issuance. Communities across the United States are already feeling the impact. Green card holders are postponing international travel out of concern that re-entry could be complicated under the new inadmissibility rules. Students and professional workers are being advised to maintain impeccable legal records to avoid immigration complications. Immigration experts agree that the coming months will be critical in shaping the long-term effects of this reform. Much depends on how federal agencies interpret admissions of conduct and how broadly they apply deportation triggers. Detailed policy memos from the Department of Justice and DHS are expected soon, which may help clarify enforcement boundaries. For now, attorneys stress caution, awareness, and complete transparency when filing any immigration petitions. The new law represents a decisive shift towards stricter enforcement and uniform national standards. While there are modernization benefits for compliant applicants, the margin for error has narrowed significantly across every visa category. Analysts describe this as a new era in which only full citizenship provides lasting security, while all other statuses carry higher obligations and heightened risk. This concludes today's report on the sweeping immigration reform now shaping the future of federal policy. For continuous updates, detailed explanations, and verified national coverage, keep watching U.S. Immigration Hub. Don't forget to subscribe, like, and share this report to stay informed on the policies influencing America's immigration system and national governance. Thank you for watching USA Immigration Hub, your trusted source for factual, professional, and uncompromising